So I think I wouldn't hold off just to park it. I would perhaps go back to your bidders and talk about how they're dealing with that. Keeping an eye on the time, I'm going to go on to the next slide, which is disputes, just to talk about some relevant case law that might be very pertinent to your particular situations. The first one being adjudication and insolvency and how that is dealt with. And we're in the week of the Supreme Court hearing the Brescoe and Lonsdale, the Brescoe appeal in the Brescoe and Lonsdale case. Their lordships dealt with this all on video link. The learned QCs were in their offices or in their homes. Everything was virtual, but the Supreme Court ran this week to hear Brescoe's appeal on this case, which relates to if a party who is in liquidation can still run an adjudication and claim money, or the liquidators on their behalf can still run an adjudication. So subject to what the Supreme Court might or might not say, I have to caveat that, but based on the Court of Appeal's judgment, we're in a situation where a company is in liquidation, then an adjudication would be futile. But where a company is in administration, there's a slight difference, because administration potentially has the ability to trade through and resume normal business trading and come out of that insolvency process. So the Court of Appeal's position was that you'd have to look at the context and look at the type of insolvency process. But a company in liquidation, where a liquidator is chasing money, an adjudication would be futile until the High Court came along in the Meadowside Building and Hill Street Management case and looked at that scenario and looked at the particular parties involved and agreed that if security could be provided, then there may be a way to allow a temporarily binding adjudicator's award to be enforced and then challenged later potentially in court. So the question there is, what does adequate security mean? And there have been some cases on offshore companies cross-guaranteeing, or bonds or guarantees, or what's in cash in the bank account. What is adequate security, so that if the adjudicator's award is overturned and the paying party wants to get their money back in court, the money is there to claim, which is the point of.
I think we have a bit of a problem. Mike, we have a bit of a problem. You've kind of frozen a bit on it. Can you hear me?
I can hear you fine.
You froze a bit there, okay?
Where did I get to?
Well, you might want to repeat the last half minute or so, because I think that's about what we lost.
Okay, can you still hear me?
Oh yes, we're all right now. We can see you moving around.
Right, so I'll just go back through that again. Apologies if the technology stalled me. So Brescoe and Lonsdale is a case about whether a company in liquidation can run an adjudication and claim payment. The Court of Appeal has said that if you're in liquidation, then the adjudication is futile. But if the company is in administration, they could potentially trade out. But Meadowside Building and Hill Street Management in the High Court faced a more inventive argument by one of the parties saying, actually, if we could put security down, if we can put some financial protection down to deal with the risk that we go bust and the money's lost, then could we please proceed with the adjudication? And the High Court were comfortable that that is an option, depending upon the circumstances, depending upon the nature of adequate security. So if there is enough financial protection for the award to be overturned, the party to get their money back safely from a company that's still in liquidation, then there's a developing line of case law. People have come with different types of security: bonds, guarantees, offshore guarantees, separate bank accounts, various things. It has to be considered on the facts, but there is this potential argument here that there's enough protection to cover a temporarily binding adjudicator's award for a company in liquidation. So moving on to the next slide, please. We're going to look at smash and grab adjudications in the context of cash being the lifeblood of the industry and people wanting to get paid. There's only so much collaboration before you have to sometimes chase payment. And I wanted to highlight the Grove Developments and S&T case. Smash and grab adjudications are still available. That is where there's a procedural non-compliance, a notice is defective, incomplete, late, and the application stands as the payment notice in default and can be claimed on that basis on a procedural non-compliance. So perhaps, you know, relevant for supply chains and contractors, and to be watched if you're a client. You can run a smash and grab adjudication. You can claim that money if you win the adjudication and get the award in your favour. The paying party has to pay first and then commence a true value adjudication. So we're keeping cash moving through the supply chain. Payment must be made against the award, and then the party who wants to then check the true value adjudication and ignore the procedural non-compliance has paid the money and then can launch their own adjudication to check that. So again, worth bearing in mind if that's particularly relevant, if the payment becomes an issue for you. And bringing us up to date with coronavirus in the TCC, and I don't mean that the virus has affected the judges, but they have considered a recent case, Millcrest Developments and Waters, this month, to do with a developer and a housing development. And the argument was based on COVID-19 and coronavirus. So just to highlight for you that this is now creeping into court, the developer wanted to stop an injunction. So he went for wanted to stop an adjudication, I'm sorry. So he went for an injunction to stop the adjudication, arguing that the absence and difficulties of obtaining evidence would be a breach of natural justice. And therefore, the whole adjudication should stop. The injunction was refused, and they looked at the facts of the case, the fact that records should be held electronically, the fact that hearings can be held remotely, the fact that the information was under the control of the developer and should have been maintained better and more accessible, and therefore refused the injunction on that basis. So the adjudication proceeded, but it does raise questions, in my view, on a factual basis. What happens if a key witness was in hospital? What happens if the adjudicator wanted a site visit and it was unsafe to do so? So although the injunction was refused, they didn't rule out the principle of injunctions. And I think we may see enforcement arguments based on similar things where the adjudication went the wrong way. And when it comes to enforcement, we have natural justice arguments because of the absence of key individuals, because of the absence of key information, hearings that couldn't take place, site visits that couldn't take place. So I think that is one to watch for the future. So if we flick on to the next slide, just practical points in terms of running a claim. So, you know, it's records, as Millcrest Developments found out, how you keep them, what information you keep, how they can be shared and easily accessible. You're looking at running a critical path analysis. You're looking at causation, direct effect. You're looking at getting in the right notice procedures at the right times to make sure that you can establish, you know, the direct cause and effect relationship of any particular relevant event or compensation event that you want to raise. bearing in mind that the JCT is retrospective and the NEC is prospective, but you should still be able to run those arguments and carry out that analysis. And I just wanted to highlight the point about concurrent delay. That again could be the subject of a lengthy webinar just on the point of the legal issues of concurrent delay. But it's worth pointing out that parties are allowed to put an express contract clause in which flips around the concurrent delay risk and puts it all on the contractor or all on the subcontractor, depending on where you are in the supply chain. It's a very harsh clause. It flips around the common law position. And you must be careful if you get contract amendments which seek to do that, because that will prejudice your ability to run relevant event and compensation event claims, as we mentioned earlier on. So look out for those bespoke clauses in any particular amendments if you're looking to run a claim. So moving on to the next slide. That is the end of my talk for today. I will go back now and have a look at some of the questions, and we can go back through anything. There's a little bit of time, so I'll flick back through some of the questions and happy to take any discussion as people wish to do so. Thank you.
If we have any questions, does anyone want to ask them by putting their hands up? I can then bring you in on the screen. We have no hands going up here, so I think probably work through the questions you've got there, Michael.
Okay. So we've got a question about extension of time rules where the main contractor has furloughed the site manager. That's a decision for the main contractor to furlough its own staff. Employees who are furloughed can't work, and I think it would be quite difficult to run a claim for extension of time where you have caused the problem yourself by furloughing a critical individual. I've got a question about 60.119, which was the NEC's version of force majeure, the event that nobody could have anticipated. If that's been deleted, there is no other English common law force majeure provision. You are, on the NEC terms, reliant on the list of compensation events that are there. So if it's been deleted, it's been deleted. People talk about the concept of frustration as a legal concept, which is a very high bar to get over, and I would suggest very difficult to run in this context. So if you have got bespoke amendments to an NEC which takes out that provision, then it's going to be much harder to claim force majeure, and you would have to then hang a claim on one of the other grounds, like an employer's risk or employer breach, change in the works information, dealing with access to site under NEC, and look for another compensation event. I don't know which side of the fence you're on, but either way round, force majeure, the NEC force majeure equivalent just isn't there anymore.
I have a couple of people who've put their hands up, Michael. I don't know whether you're happy to take some questions from them. I'll bring them in.
Yes, absolutely.
Okay. So one is Pedro, I'm going to bring in now. So I'm going to promote him to a panelist, so he'll be seen on screen as well. I've got Anthony Collins I'm going to bring in as well. And I'm going to bring in Andrew Carpenter.
Hi there.
Yeah, hi. Thank you very much for the workshop and giving us a bit of guidance on the current matters that we're encountering for, you know, what we might suffer. A quick thing I would like to ask is, could it be the fact that we had the COVID-19 and the government brought the new legislation, as you know, the certain regulation of COVID-19? I found that a lot of sites I tend to look at, after the insertion of the legislation, they start to be locked down. Would it be a thing that the contractors were waiting for that legislation to happen, or something along those lines for them to take action? Could that be something to be aware of?
Closure of sites. They might have been waiting for decision. They might have been waiting for decision from the government. But I don't think the government are ever going to say complete close down. I think the CLC guidance talks about dealing with safety. So I think as you'll see, sites are opening up again. They might have been waiting for legislation, assuming it was complete lockdown, and then realised it wouldn't quite go that far.
Were you happy with that, Pedro? I think it was a bit of a microphone problem at the beginning. Were you happy with Mike's answer on that? You might just need to...
Mike was muted for the first 30 seconds.
Yeah.
Oh, was I? Can you hear me okay?
Yeah.
No.
Yeah, so I think, as I say, a lot of contractors initially immediately shut down their whole site for safety, expecting that the legislation would come out requiring them to do so, and it never quite went that far. So I think as people had a couple of weeks of risk assessment and a couple of weeks to consider their supply chain, they're now reopening in a different way, dealing with situations in a different way, but just preemptive anticipation of the legislation is always a different thing, and I think that would have been the contractor's risk to deal with that. Trying to second guess where the government would go with this was a high risk strategy, and I think one or two of the national contractors used that time to re-evaluate how they would deliver the works, given that it hasn't been shut down.
Okay, no problem. Thank you for clarifying.
It's all right.
Are you going to bring in Anthony?
Anthony's microphone's open, but he hasn't got his camera on. So, Anthony, can you want to ask a question?
Yeah, it's, thanks for that. It's, thanks, Mike. Interesting to hear that seminar. The one thing I was going to query, I don't know if I missed it earlier, was we do housing contracts, social housing contracts in Stock in Swansea. We're doing re-roofing, etc. Back in March, because of our tenants, we've decided we've virtually told them not to open up any new work, to not strip any roofs, etc. That has been the case now for almost 2 months. Is it a time, we haven't had anything from the yet regarding early warning notice because of our instruction. But when it does, is that just a time one we'll be looking at, or will it be time and money? It's an NEC3 contract, sorry.
Yeah, if you have been told to work in a different way, then that is, in my view, that's time and money. They are imposing changes to the works information. They're imposing site access restrictions, things like that. I think that's much more likely to be time and money if you've been specifically told how to do your particular works. Right.
Okay. That's the question I was asking. I was just wondering if we just give them an extension of time. We're acting for the client on this one. emergency housing. Because of our attendance, we've actually said, look, it's not safe for us to let you carry on working on certain parts of the job. Like we're carrying on with the external weather vision, but not with ticket stripping rules. So that's a time and money. That's what you're saying.
Well, I think that's an interesting point. So health and safety, the clients are supposed to take steps that are reasonably practical to protect health and safety. If you have to make decisions that you're going to refurbish housing stock that is being lived in and not new, and you've looked at the situation and you can't keep 2 meters away, could the tenants go out for the day? Possibly not if they're elderly or disabled. If you can't keep 2 meters away, and there's no other way of doing it in terms of, face masks, gloves, contact, the way that the work is done, then you might possibly get down to having to stop in those circumstances. But I think that is time and money, because the client would be in breach then, and the client would have to make a positive decision, in my view.
Okay, that's answered that. Thank you very much.
Mike, we've got a number of questions and answers that have kept adding on to the menu whilst you've been speaking. So I don't know whether you'd like to go back to that. For everyone who's still hanging in, we have gone over time, but if you'd like to stay, I'm sure Mike will be quite happy to answer the questions. So over to you, Mike, to have a look at the Q&A menu. Many thanks.
That's fine. Yeah, so going back to, again, another question on the deletion of 60.119 in NEC. So again, you're looking for another hook to hang the compensation event on, depending on the circumstances. Is it the contractor making the decision himself to reorder the works, or is it actually a decision required from the employer in terms of access, in terms of release of information, in terms of other impediments that the employer might create? Yes, again, similar question, unamended NEC 3, which party is responsible for additional costs associated with complying with CLC SOP version 3, I think is the latest one. I think that's the contractor, in my view, depending on the circumstances. Again, the contractors are supposed to be carrying on site operations. They're entitled to an extension of time for doing that, but it depends on the costs and the circumstances. I think it's potentially, I know it's a fact-based answer, depending upon the particular job that's going on, particular delay, I think, on that one. Does COVID-19 constitute force majeure under JCT? I think it did 4 weeks ago, 6 weeks ago, when nobody was really sure what it was or how it was going to happen. I'm not convinced myself that that argument is as strong as it was now, because people now understand what they can and can't do and the impact that it's going on a bit more. And I think there would be an expectation now to mitigate that in a lot greater detail now. So I think just you saying it's force majeure is a harder argument to run just in the last 4 weeks, and how the information flows triggered risk assessments, guidance coming out from everybody.
Does that conclude the questions, Howard? Mike, is that?
Well, I think
there's a lot of questions, so it depends when you want to draw a line under this.
Okay, am I missing questions then? I can't see them in my Q&A box.
Well, there's 18 open. I'm not sure how many at the beginning were actually answered, because as a non-lawyer, I wasn't quite sure how to read it.
Would it be, is anyone listening in? Could you put your hand up if you feel your question hasn't been answered? I'm just aware that we are over time, and I don't want to extend too long, because I realise people's time is precious even in these conditions.
Jenny Saunders has put her hand up, so I'm going to bring her in.
Bring Jenny in, yeah.
Yeah. Anyone else, please raise your hands. That's all. Jenny, you'll need to put on your microphone at least to speak. I've unmuted now, Jenny.
Can you hear me now?
Yeah?
Yeah.
Hi there.
Okay, great. So I have a couple of questions. So one, a project is complete in all but one item, which is a gate which needed to be installed. This is a JCT. And they can't install it due to the supplier shutting down. So in terms of issuing practical completion, is there a mechanism where that could be issued excluding this one item, or would it be a case of the contractor needing to apply for an extension of time?
Practical completion is a very high legal standard, but unless the gate is on a prison or somewhere where that gate is critical for the whole purpose of the particular project, then I would say, you know, if everything else is finished, you could look at issuing practical completion subject to, you know, rectifying the missing gate during the defects period. If the gate is critical to the whole purpose of the project, that's a different matter.
Okay, that's great, thank you. And my other question was more of a general one about site access. And for instance, if a QS and potentially the architect is unwilling to visit site due to safety concerns, would seeing photographs and potentially video calling on site, would that be acceptable for inspection of works, or not in this instance?
Architects operate under a duty of reasonable skill and care, judged against what their competitors on similar projects doing similar work would do in the circumstances. So I think it potentially could be okay, because I think we have very good technology available to us. You could potentially send somebody with a live video feed, one person on their own, to be walking around the site. That's perfectly safe if no one else is on there, and you could, you know, depending on the valuation. So I think it probably could be okay, unless there was something that you really needed to get in and look at, you know, face to face.
Okay, that's fantastic, thank you.
Are there any others, Howard?
No one's put their hands up, so I think if you'd like to close us down, that'd be super.
I just think we are taking people's time. So first of all, Michael, thank you so much for your knowledge and expertise. I think that the fact we have overrun 10 or 15 minutes is an indication of the interest in what you had to talk about. And I think at its peak, I think we had 100 attending, so that's a good attendance as well. To the rest of you, thank you. Howard and John in particular, I'd like to thank you for hosting it. And for those that are asking about the presentations, yes, they are available. You can go to a Constructing Excellence website or Leaders Meets website, but they are available for you following this presentation. Just as an explanation, as I wasn't here right at the beginning, these webinars are being brought to you now every week on a Tuesday and a Friday at midday by Constructing Excellence Southwest, Constructing Excellence Midlands, Constructing Excellence Wales, the Housing Forum, and the Structural Timber Association, all of which were organising them independently before Easter. But we thought we'd pool our resources and run them twice a week. So thank you for your interest. We've got two next week. On Tuesday, we have Louise Townsend from Morgan Sindall, who's going to be talking about social value. And then a week today, on Friday, we've got Paul Chatwin from Cundall talking about net zero. We think it's time to broaden the subjects beyond just the coronavirus. So next week, we're going to branch out social value on Tuesday, net zero on Friday. But also next Friday, really interestingly, we've organised an additional one for Friday evening. So we're going to ask you to turn up at 7 o'clock when I will be interviewing Boris Johnson. Okay, and you too will have the opportunity to interview Boris Johnson. We haven't gone live yet because we think the interest to this one is going to be massive. We're going to run it a little bit like the government procedures at 5 o'clock, the updates. So if you've got questions for Boris Johnson, he's going to be with us 7 o'clock next Friday, 1st of May. Details will be out soon. Don't miss it. Thank you. Good afternoon. Have a spectacular weekend. Thank you.